DWI NJ, Part 1. Okay, let's start off by looking at a brief overview of the statute on DWI. What constitutes that conduct? This is a very, very in-depth and complicated piece of legislation that you need to fully understand. First, you got to understand that there are two basic different kinds of DWI. The first one is being impaired by alcohol, which will be discussed at length here. And in a subsequent video, I will detail DWI by prescription drug or recreational drug. And that'll be discussed in a subsequent video. Okay, so the statute makes it a Title 39 driving offense to operate a motor vehicle on the public roads of New Jersey while impaired by being either under the influence of intoxicating liquors or the influence of hallucinogenic drugs. So essentially, the act creates the breathalyzer as the state's main witness. Now, the way this is supposed to work is when an officer suspects you of drunk driving, he's supposed to first find a traffic infraction that gives him a reasonable suspicion or probable cause to believe that you are impaired by something while operating the vehicle. Usually it's improper lane change, weaving in and out of a lane, 488A, something of that sort. Then he pulls you over. Then if he either smells intoxicating liquor, like you smell like a beer brewery or a vodka distillery when you roll the window down and give him the license and registration and insurance ID card. Now he has probable cause to ask you to get out and do what's called field sobriety testing. That testing is supposed to test your balance of coordination. There is the horizontal gaze nystagmus with the lit pen in your eye to track the movement of your eyeballs. This is supposed to give him a clue as to whether or not you're impaired by alcohol or drugs. Then for alcohol impairment, there is the heel-to-toe touch walk and the single leg raise test. If the officer believes that you are showing signs of impairment because you can't do these coordination and balance tests properly, and there are clues that they use to determine whether you're impaired, then he says to you, okay, you're under arrest, I'm taking you out of the police station, you're going to have to take a breathalyzer test. Now, what's important about this is the breathalyzer, commonly known as the alco test machine, is the state's star witness in these cases. Because why? Because the statute says if your blood alcohol content is 0.08 or higher, you're automatically per se guilty of driving while impaired. Doesn't matter whether you tolerate that or can tolerate that alcohol level in your blood and drive well, you're impaired. So a large part of winning these cases is showing that the machine was not operating properly, the readings are not reliable for whatever reason, and they should be suppressed. For that, you need an expert witness because, a lawyer can't testify at a trial. And a non-expert or layperson isn't qualified to give that kind of testimony. So that's a large chunk of how we defend these cases. Now, if you're lucky enough to get the reading suppressed, now you're down to how'd you do in the field sobriety test. So that's also a consideration in these things. And then, of course, there's how many times or priors have you been convicted for DWI in this or any other state. That also figures in. So I've handled many hundreds of these cases, and some that I should never have won, I was able to win because there was either police error or procedural error, or there was machine error or machine unreliability. So under the precedent of State versus Chun, that's CHUN, which is a Supreme Court case that dictates, the procedure the police got to follow when they do the Alcatraz test. If we show that they violated that, you may have a chance to win. Now, what are the penalties? Just very briefly in an overview, first offense of under 0.10, if convicted, it's a 3-month loss of license, a fine, no jail. On a second offense, if you have one prior conviction in this or any other state, and you're convicted again within 10 years from the first time, then it's a 2-year loss of license, possible jail from 2 to 90 days, and of course, a monetary fine of somewhere in the neighborhood of $800 to $1,000. The really serious part comes in if it's a third or subsequent offense. So you've got 2 prior DWIs, and the second one was less than 10 years ago. You're looking at a third time, and the statute says 6 months mandatory jail in the county jail, 10-year loss of license, and approximately a $1,500 monetary fine. Some people just can't afford to lose their license. They got to drive, make a living. That's the situation. So anyway, my name is Stephen A. Gravatt. My telephone number is 732-337-7922. My website is www.njdwicriminaldefenseattorney.com. If you've been charged with DWI and you are really upset about the havoc it could wreak on your life, give me a call. I might be able to help you. Thank you, and have a nice day.